So what is a trust and why am I here? What is a living trust? A living trust is basically a piece of paper, document, that's going to identify what your wishes are. What do I want to have happen? Under what circumstances? If I have an incapacity in some kind, health-wise, it's going to help us to be directed as to what we want. If I'm no longer here, I pass away, it also is going to do that. So it's a legal document. It has to be notarized and it has to be what they call funded. How are we doing? Can everybody hear me? I speak usually pretty loud, but I guess they want me on this mic, right? Okay. Sorry, we have a PowerPoint that might help you, so that's what we're doing here, all this technology. While they're doing that, I'll tell you what's in front of you. How's that? So what I've left you is a brochure. It's with Ameristate, is the attorney group that I work with. I'm an advisor for them because of my tax knowledge and my financial. I'm an advisor for Ameristate. So once you make a determination that there's a possibility that you need a living trust, then we contact them and then they go through the final legal data with you. And then you can come back to me if you like, we can notarize it or they can do the whole process. What I do is a lot of the initial fact finding as to whether or not this is something you really need to do or have some idea that maybe you want to do it. So that's kind of where I come into this. I really am helping them to keep the cost down so that it's not as expensive to you, but you still end up with a really great legal document at the end of it. So I'm usually the initial contact, making the determination whether or not you even need this, and then we go off to the attorneys and then they handle all the legal write-up of it and then the finalization. There's also a piece of it which we'll be talking about in here, which is called the funding, and we'll go through that as well. The other thing that's here is if you want that information, that's what the orange sheet is. You can just fill that out and give it to me at the end. The other deal that is here is the actual advanced health directive that the Father has provided to us. This directive helps you through the Catholic guidelines. It's actually a part of any living trust that you do. If you just do the directive, that's what is going to be a separate item. That would be totally outside of it. But it is a part of our living trust, if that's... Oh, my probate? Yeah, this is, I'll just kind of jump to this because everybody's going to see him. This is Patrick, my probate thief. And basically that's why I'm here and why you see the money. Because the idea for me, for what I do for a living, is to try to financially, and that's what WIT is, winning in tough times. It's helping people to avoid those tough times, but if they're already in those tough times, I'm trying to help them find their way back. So and tough times can be a lot of tough times. It doesn't necessarily have to be just financial. It could be an emotional situation that is coming on with financial issues, and a lot of this is death, incapacity for a mother, a spouse, somebody. So there's a lot of things that winning in tough times is trying to either avoid and or once we're there into a bad situation, try to help unwind it. It's okay, I can just keep talking. So my probate thief, The idea of the probate thief is that it's a legal situation of probate. Probate means that we have someone that died without a will. Even with a will, they'll go into probate. They died basically without a living trust, and they have more than $150,000 in assets. Those assets, because now there's no way for the courts or anyone else to know what to do with those assets, it's going to go into probate. So now we've given the state their plan, not our plan. They now have certain rules and regulations that they're going to go through, and that's how your estate and your children, how everything is going to be decided is by the rules and regulations of the state.
One little closer.
Okay. Question? Okay.
Are you taking questions, or are you just going to let?
I'm-
We will be taking questions. If you do, I have a microphone that you guys can speak into, because this video will be going on the St. Louis website. Do you have a question right now for, was that your question, or do you have another
No, I
question?
have a minor question,
Okay.
but I know most of the people here, so I don't, need a microphone. Is the average, Raven, is the average cost for probate in California 10%?
It is. That's what the going conversation is yes. So now we've taken 10% of, so let's just say that we make it over that threshold of the 150,000, okay? And let's just take a number of the 200,000. So now we have a $200,000 estate. We just took $20,000 away from that estate and away from our loved ones, and we basically gave it away to the attorneys, and that's why I call it my probate thief. That right there is in a nutshell. It's not just the financial part of it, though, as well. We now have lost someone. We have that emotional that we're dealing with, and on top of that, now I can't get to the assets that I need. Things are tied up. I've now added more stress to my loved ones, to the family that I left behind, because I didn't take this proactive approach. We're up. Okay, how do I move the... How am I going to move this screen? Do I have to walk over here, or? Oh. Sandra, you're the bomb. All right. Woohoo! You were a find. Okay.
I can never get her on the phone.
Let me make sure that I'm doing this right. Is that it?
It's just an arrow. Yeah. Okay. Okay? All right. So, like we just, I'm already hitting all the high points, but what's the importance? And this is an estate plan that we're talking about. It's an overall estate plan. Part of my plan, or what are my goals? So my goals are to protect my family. I want to provide for education. I want to have a child. Oops. There they go. Yeah, you can just go ahead and hit them off. Yeah. So I'm trying to make sure that my wealth, like we were just talking about, our probate thief here. So we're also trying to make sure that our wealth, that we're not giving away 10% of our wealth and we're not talking, we don't need to be Bill Gates here. Okay, I mean, $20,000 is a significant, in my world, a significant amount of money to just give away and not to be able to have for my family. So when we're trying to say we're trying to protect them, we're protecting them from stress, we're protecting them from financial issues in that 10% that we don't want to give away to the probate thief. So we also want that peace of mind. We want to know that what my wishes are, like I said, we don't want the state plan, okay? We don't want their legal ramblings to tell us the way that this is going to go. We want our plan. We want our wishes to be known. That's what the living trust will do. It puts it in writing, it notarizes it, it lets everybody or anybody after I'm gone know this is the way that I expected things to go. Or I don't even have to be gone. Again, I'm just not mentally capable any longer. Again, I don't want a state conservator. I want my wishes in someone that cares about me, that I've chosen to make those decisions. Maybe I want to make, as far as my legacy goes, perhaps I want to leave money to the church. I want to leave money to some other charitable organization. Again, wouldn't that $20,000 that we keep coming back to, that 10%, wouldn't that help the church as opposed to going to the attorneys and to whomever? Okay. So what's the plan? If we have a goal and we don't have a plan, we're really just wishing upon a star. It's not going to happen. So a lot of this, hopefully, it's sounding maybe very complicated. You see this book that I keep pointing to, and you start to look at this portfolio, and you, holy Hannah, what's in this? Okay, it's a big book, it's a big binder. But again, there's state rules, there's attorney rules, there's legal rules, and it's for your protection. It's not to overwhelm you. And the complication, it may seem like it's complicated, but it really, if you have the correct advisors and somebody that's walking you through these different decisions, and there's several, but you're making those decisions. Someone else is not making those for you. That's the benefit of a trust. Okay. So it's easier than you think. Oops.
What happened?
I think you went the wrong way. So again, we're talking about avoiding, why do we want this? We're avoiding probate. Also, I'm not sure if you're aware, but probate is public. You now have lost some of your privacy. Your world is out there for anyone that wants or chooses to go take a look. That's the other thing that probate does, is it now makes any of your assets, whatever your world is, it all becomes public knowledge. Where with the living trust, again, it's a little bit behind the scenes. The world doesn't know what you're doing. So privacy. You're providing for the property distributions the way that you may want them to go. Again, it's protecting your wealth, deciding how you want things to go. Again, that's in written form. That's decided. It has a living will and a power of attorney within it. The power of attorney, again, is based on I'm incapable for whatever reason of making these decisions and handling my affairs. That, again, is within the living trust. It has a power of attorney for someone. Now, it immediately, when I'm signing this, and I have clients that say, well, I don't want to give anybody a power of attorney. It's only a power of attorney under specific conditions. And again, you set those conditions. You go through that with the attorneys. You decide under what situation do I want this power of attorney to come into play. I recently just had one of my clients call me freaking out because she thought her mother now was not able to handle these financial decisions. We had done a living trust for her. She forgot that there was a power of attorney within there that kept it from going into a conservatorship and having somebody that did not care about her mother make these decisions. It was already there. All she had to do was pull the trigger with the power of attorney. Yes, sir?
Isn't there a distinction between a healthcare power of attorney and a financial power?
Absolutely, absolutely. And this is an incapacity, not the advanced healthcare directive that I was just referring to. You're absolutely correct. And again, so what we're allowing for within this is also our legacy. What do we want that money to do? Where do we want it to go? So there's 4 steps, simple planning steps. And I'm not going to jump to saying that it says simple. I'm not going to tell you that you're going to walk away thinking that this was simple. I don't think it's simple. Whenever you're making decisions for things that you aren't quite sure what's going to happen, it's never going to be simple. But you're going to have some pre-thought to it. You're not going to have the emotional kinds of things that is going to happen later without the paperwork already in place. It's going to be 10 times worse. So making these decisions, again, without having the absolute, okay, somebody's passed away and now I have all this other stress. This is going to be difficult, but not as difficult as it could be later. So this is preempting. So what are we doing? We're going to find someone for our power of attorney with a successor. We need the successor trustee and we need an executor. So that's where we're going to have to find someone or have someone in our life that hopefully we have, that can be trusted, that we can make this trustee or that we can use for these people. So we need to identify those people, and we also will identify alternates, just because things happen in the world. So we're going to also identify what we want, who are the heirs, what's the percentage, what's the timing. This is a great motivator. If I have a child that's 21 or 22 years old and I have an estate that I know at 21 and 22, yeah, maybe this child is vacillating, maybe they're not quite ready to go to college, they're not sure what they're going to do. I can, within this document, put some motivators that, hey, you finish your 2 years of college, you get X amount of dollars. You finish your 4 years of college, you get this amount of dollars. These are the kinds of different things that you can make the choices within your trust, and you can discuss this with the attorney to say. So these can be motivators as well. Charitable giving, again, you can identify who do I want to give this to, how much do I want, and where do I want these monies to go. So if I have a minor child, I'm definitely, or a special needs, I'm definitely going to want to have some kind of a living trust for my estate. I'm going to want to identify who is that guardian, what do I want to happen with that child. I don't want, again, to just leave that up, that the state now can make those decisions. So important choices. So obviously, I'm not capable of making decisions. That power of attorney, again, is going to be extremely important. And now we're talking to the financial power of attorney. I'm not talking in terms of the health directive. This one is, I want to make sure that I have someone that's trusted. There's different people. There's actually corporate executors that you can have, that if you feel that you have someone in your life that's a trusted banker or someone else on a financial side, and you want that person to be, that can also be there. You can also have that person. It's, again, these are people in your life that you need to make, and that's why I say these are not always simple decisions. I'm not trying to make this a simple task. It's not. But it doesn't have to be from a legal standpoint. It's more of an emotional, I think, on those things and making those decisions. It's not that the paperwork and the legalese has to be the difficult part. It's within you that you have to find those answers as to who's around you that can help you. So again, so we're avoiding the conservatorship. And in death, who do I want that's going to manage my different estate? What do I want to happen at death? So that person, so I need to, again, I'm going to have the trustee to administer the trust. So I have a lot of people that ask me about the trust from a tax viewpoint. So I'm going to hit that just real fast. Does it have to do a tax return? Not while you're alive. The living trust is truly that. It's a living trust. As long as you're still here, the trust itself, that living trust, does not have to file a tax return. So a lot of people think in terms of a trust, and that's where I think that they take it as that it's going to be so difficult, and that, oh my gosh, I have another tax return and I have this to worry about, but that's not the case. Now, once I pass away, yes, there is some management and there is a return that will have to be done. But you'll have to do, that trustee will have to do executor will have to do a final tax return for that individual, is what will have to happen. Yes, sir.
Oh, can you tell me if there's any advantage or disadvantage to choosing your own social security number for a revocable living trust or choosing an entirely different social security number? Are there any advantages or disadvantages?
Okay, this goes to exactly what I was just saying, that it's not truly an entity. So it's really, at this point, it's a piece of paper and a roadmap for people to know what to do if you're not here. At the time when you're not here, if there's a necessity for a trust, that will not follow under your social security number because you've passed away. So that's where the final tax return for you as an individual will come into play, and you will actually have to, or someone will have to, as the executor, have a federal ID number, and now there will be an actual closing entity. So, for instance, if I have documentation that is after my passing, now I have something that I need to cash a check, okay? It needs to be in the estate of. That estate of will have, with the bank, you'll go to the bank, you'll set it up with a federal ID number so that you can have a bank account to now close out and to now cash those funds.
So when
Does
you're
that make
setting up
sense?
The trust, it's irrelevant whether you use your own social or
You have to use your social, you're identifying that you are the one that's setting it up as,
You can set up a trust without your own social security number.
it's not, this is a living trust, it's not a trust document. It's a revocable living trust, that's correct.
Yeah, you can set that up without using your own personal social security number.
Yeah, but you're not really doing any filing with it anyway.
Right. but I'm
Yes,
just saying you can. I just didn't know whether there was an advantage or disadvantage
No.
one way or another.
no, no, if I'm understanding the question.
What's the difference between a trustee and an executor?
Okay. You are actually a trustee of your estate when you get started. After you pass away, there's actually an executor. The executor will then take over,
So you're considered
the original trustee, and/or your spouse also. Usually, the trustees are of one another, so yes.
So if that's the case, what's the difference between an executor and a successor trustee?
A successor trustee would be my first trustee may or may not be my spouse, or my spouse has now passed away. So now going forward because my trustee was my spouse, so now my spouse has passed away, now my successor trustee would kick in.
So how is that different from being an executor?
I usually, as the spouse, would be considered the executor as well. So it's now that there's a different event, the wording has changed.
So if, let's just say you and your husband, you both pass on, so your successor trustees are the children, are any of them an executor?
No,
They're not.
not unless you set it up that way.
So then you would have to choose, someone else would be the executor.
Right.
possibly necessary.
You normally pick 2 or 3 people, right? One
That's
for
what
first,
this,
one
that's
for
what we're discussing, that's right. You have your original trustee, and then you have some successors, because things happen. And you can change that at any point. You know, at the point when you're drafting this, you may have it all set up, and then think later, 2 or 3 years from now, I don't want it to be that way. I want to make those changes. And that's very doable and very easy and not a big deal.
I'm sorry, I'm having a problem understanding the difference between a trustee and an executor.
Okay.
I know I would be the trustee.
Yes.
If I'm still alive.
Yes.
And after something happens to me, then you can assign, designate a trustee, but then again, is that trustee the executor?
Maybe it's clearer if I do it this way. I'm a single person. I don't have the spouse, okay? I'm saying that I'm going to have a trustee on my trust. I have a trustee. That trustee could be my daughter, okay? I also make, as my executor, I can have co-executors. So now I'm gone. So I don't have a spouse. So now I'm gone. Now I have co-executors that are now going to facilitate my trust. So while I'm alive, I can have a trustee that's going to make perhaps those situations or those conversations about when I'm not here, I'm not there. I don't necessarily need an executor for that. I can just have my trustee.
Okay, so the executor comes into play after you're gone?
Yes. Okay. Yes.
Can the executor be beneficiary of the trust?
They can be, yes. They don't have to be. And I actually just recently had a case where the executor was not, and it was a lot more work than they thought. And they were like, I'm not even getting anything out of this. I'm not a beneficiary. Now, there are executive fees that you can ask for. I'm not saying the executorship is an easy deal, and I try very hard, and I think most of the attorneys that you'll work with will tell you, make sure that you've spoken to the person that you've chosen, because this is not, being an executor can be a little overwhelming sometimes. So again, yes, it's definitely doable, and there can be executor fees, and those are limited. So again, an executor can be doing a whole lot of work and not a beneficiary of this. And that's always interesting.
So you say if anybody asks you to be an executor, make sure you have the fee thing.
I just am saying that there needs to be conversation, because you'd be surprised. Somebody that you thought would take that position on and welcome that and be okay with that, if they've ever talked to someone else or they've actually seen it go down before, they may be reluctant. So I always say you want to make sure that the individuals that you're thinking are going to be cool with this, may not be. And there's so many dynamics to this. I mean, you with family, you're making choices. You have 4 children, okay. So there may be one in the group that is a numbers person and totally great with money. And you're thinking, okay, that's the person that you want to be doing the executor. Well, now I've got these other siblings that are like, why did mom choose Don to do this? You know, it's the way it goes. So again, and that's why I suggest once you've done all this and you've made your decisions, and I'm not saying that you change it, but it's always helpful to let the family kind of know this is what the structure is going to be, sort of warn everybody so that it's not, you know, a big surprise. Because you're not there now to fix those squabbles or to calm everybody down. You're gone. And you just made those decisions and now they're just seeing it for the first time. That could be bad. It's been bad. I've seen it be bad. So I always suggest people talk about it. And again, it's not a pleasant, and you're going to have those that go, I don't want to talk about this. You kind of have to talk about this. You have to talk about it. It's a part of life is death. So, you know. So, yeah. So again, talking about, that's what we're talking about. The next one here will be guiding your decisions. How do you choose the right people? You know, what makes a good trustee? What makes a good executor? Those are the people around you. Those are the situations that you're going to have to make that call with the people that you know around you. And again, like I'm saying, there's individual versus there's corporate. You know, you have to, again, you know your situation in your circle. And this is where the attorneys are really good to talk it out. They will help you. They will guide you. They've seen everything under the sun that could possibly come down the ramp. So they will help guide you. They will tell you, you may want this over this, or think about this. So they don't know the people in your life, but they can give you the different ideas of why you may want one person over another. So like a trustee, one of the stories is, I have a trustee, they're living in my house for free. You know, do I really want that person to really be making the decisions? Maybe not. Because obviously, why would they want to make a change, or why would you see what I'm saying? You have to think a lot of this out and talk it out, and you know. Okay, so identifying those people with the health care and those decisions. Father left us the health care directive on your desks, and you may want to go over those as well and just really read. I find, I can tell you personally, the healthcare directive is one of the most difficult pieces to make those decisions. And I will say to you, do not hold up the rest of your trust based on the healthcare directive. You can do the rest of the trust, the rest of the living trust without this. I'm not saying that I don't want you to do a health directive. Please don't misunderstand me. I'm just saying to you, this piece of the decision is very difficult. You may want to talk to Father, you may want to talk to the attorneys to really understand it. I actually thought that I understood it, I'll just personally tell you, a lot better than when I was put into the real life situation for myself in my family. And I will also say, and it's no disrespect to the medical field, there's a different mindset in the medical world these days, and you need to take that into consideration. You need your advocate to be very strong. That's all I can tell you. Because the medical system is not necessarily reading your Catholic teachings. You need to be very clear with this directive, because somebody's going to have to be standing there with that right in their face saying no, no, no. So, and again, this is not meant as a medical bash at all, please. It's not meant that way. What I'm saying to you is when you're personally in that situation, you're getting pressure and pressure and pressure. So please, please do this. Please do this, because they have a lot of power. So this is an extremely important piece, but so is the other piece. But I don't want you to be held up on the trust itself, giving away money to the state and not having those decisions made. But this one does need to be made, but I would not make it as though if I can't make this decision, then I can't do my trust. Okay? That's my take. So, thankfully, my mother had hers done. So when we were put in this position, it was all clear. But even that, I gotta tell you, it was very difficult. It was really, really difficult. Because you're fighting a medical machine that has their own agenda. So, whatever that's worth. That's very personal, and that happened just very, very recently. So it's probably a little closer than I like to talk about, but there it is.
I already have the living trust, everything is set up, and I just don't want to be kept alive with machines. I don't want to be kept alive through feeding with tubes.
Does your
in my
living trust,
stomach.
and have you reviewed it, and have you reviewed your health directive in the last year? 2 years, 3 years?
I have.
When did you
filled
do the
out
trust?
paper. My doctor has the
Okay.
DNR in
Okay.
in my file.
And
I
it was
don't
something that
want
was
to be-
recently done?
Excuse me?
How long ago was it done? The wording in these things has
About
changed.
5 years ago.
How many?
5 years ago.
Okay, have it re-looked at, please. Please
Okay.
have it re-looked at.
Is it different?
There's different language in these directives within the last few years, so just have it looked at. Everybody in here is a little bit different, so I don't want to make a, like a general type of a statement. But if you have not had your living trust reviewed or looked at, or if you already have one, I would fully and strongly suggest that if you had it done more than 5 years ago, that you have it reviewed.
Okay.
Who has to look at it, an attorney,
Another attorney is going to want to look at it.
other than the first one that did it?
I would have the first one, I would go back to the first one, and that's the beauty of my situation. They're happy to go back and they'll review and they'll update. So I don't know whoever, wherever, if you have one, please have it looked at again with the language if you haven't had it looked at within the last few years. Yes, ma'am.
This health directive, has that been done with an attorney?
Yeah, well, the wording of it has to be done with legalese, yes. So a lot of the hospitals and a lot of these different places have these health directives. But again, if you read this one, okay, if you have specific type of language, and that's what I think is in there, specific type of language that you want to happen, you need to make sure that that language is in there. And you have to have it notarized. It's just the paper itself won't do you any good.
I just filled out one with my sister at City Hall. They provided the paperwork.
Okay?
It was left with her, and it was her and I filling it out.
Mm-hmm.
And I found that the nurses and the psychologists.
Nobody's going to tell you.
Nobody's there, but I was frustrated with my sister because she was answering too fast. I said, think about it. I was telling her, look
This-
at this.
thank you.
Look what you're giving. And
See-
that was the hard part.
Yay.
Because I was telling her, what do you say yes? What if it's somebody else?
That's right.
And then but they came, and they gave the paper, and then they brought another
Mm-hmm.
to do the final thing. But I thought that they were not trying to influence you at all. But yeah.
But they
you
can't
have
really
their things to
explain
say.
it for you. They can't really explain it to you. You need to really speak to an attorney, and then from the attorney, I strongly suggest you talk to your spiritual guidance as well.
And that's why we're doing this now, Blanca, so that we're all prepared, 'cause that's what it is. Rather than, because my brother was given one when he was, looking death in the face.
Correct.
And you're answering it like, oh my gosh, it's very nerve-wracking, too fast.
Yeah.
Right.
You're not thinking straight, it's
That's
just
right.
hard. That's why you do this
Ahead of
now,
time.
while we're
It's
doing it
preemptive.
all the time and preparing.
It's preemptive.
And one part that I remember is that they said, the person in charge to execute your will, or whatever your desires, do you give full power for them to decide everything, or do they want you to, that person to follow what you want? There was a line there, a difference that, do I give my daughter power to decide anything, or do I tell them what I want.
You're telling them what you want, and then that person is then put in place to help make sure that, again, that's where I go back to me as the advocate for my mother was to make sure that what I knew she wanted that was on that sheet happened. And again, you have to make sure of what is the interpretation. And again, you need to, if you're the advocate, you need to make sure that you're really clear. What is the interpretation of what I just marked? What does this really mean? So when they come at you, which they will, I'm sorry, they will, they're going to want you to be doing X and thus at these doctors, you're able to very clearly say, here's the directive, this is what they signed, this is what the understanding is, and that you know from a legalese side, what it means and where your power is. Yes, sir.
We've had my wife and I have had our advanced healthcare directive updated in recent years. However, some medical facilities that you go to will not accept it. In instance, recent months, my wife had outpatient surgery scheduled in Glendora, and when she went, they would not accept the healthcare directive and said if you want to have your surgery, they would do it without it. If not, then you have to go somewhere else.
Was the healthcare directive done by an attorney, or
Yes.
was it?
Oh, yes.
It was done by an attorney.
Yep. Notarized everything.
And did they specifically indicate
They would not accept any healthcare directives,
at all?
period.
That's odd. I don't even know how to address that. That one's odd.
Should the hospital be Catholic?
It's, they don't need everybody, every hospital or anyone has directives, advanced healthcare directives. So it may be helpful to have a Catholic hospital if you're following the Catholic beliefs. I will say that. Yes.
My question is, we're talking about like revisiting. You know, we're trying to do these things early because it's good before the motion. But then, you know, if we do it very early, it might be time changes. Lots of things happen. So
That's why you go back.
How do you have a recommendation? How often? Every 5 years? Every 10 years?
I personally would say that at least every 2 years that you look at things. I'm putting together, and it's interesting. Right now is, of course, tax time. So, you know, here we are, we're in January, everybody's putting all their tax stuff together. To me, that's a great time, just like when you're doing your dental, you know, annuals, you're doing your physicals. Now it's time to do your overall financial annual. So now we kind of look through, we identify again, and we should have a folder for that anyway, along with like our tax stuff. And now we have this annual situation permanent file that we're going through and just kind of reviewing. Is this once a year deal? Well, I'm doing my taxes in my head. It's a perfect time because I'm not going to forget it because we're not going to forget taxes, right? So to me, it's a great time to just kind of review all of those documentations, making sure that all those beneficiaries are still what I want. Just kind of looking through this again. Is this still the same way that I want it? So again, to me, but that's me, you know.
Review on your own or with a lawyer again?
I would probably do it on my own for starters, and then if something is that radically different in my mind, then I'd pick up the phone and talk to the attorneys again.
But
Yeah.
you can even make changes on your own.
You can, it's revocable. You can't just change this, but you can make changes with your attorney, yes. It's a revocable document. Yes, ma'am.
Make sure anytime you make a change, it gets notarized.
That's the deal, is there are certain things within there that you do, and that's why I'm saying that if they're major, you're going to have to do that with your attorney, because otherwise, you just going in there crossing names off and all that, it's, you know, no. No.
We're done.
Yes, ma'am.
My funeral directives, which I haven't done yet, are very important to me. And a priest in Needles, California told me, make sure to tie that directive into my will. That if I have 3 sons, none of them practicing Catholics, and with one of his parishioners, they just ignored their mother's wishes. And so to absolutely tie it into my will, if they do not follow my directives, they are disinherited.
Yes. Okay. So, you know what's going to happen, though? Let me just tell you. if one of those sons are now going to be making the decisions and it affects them financially in some way, if you know where I'm going, So, you may want to have someone else as an executor, and again, this may be a prime reason why you want a living trust, and a outside executor, because that executor then will trump the boys. The executor then, and this is real life, guys. I mean, there's legalese and, there's all that, but this is real life. This is what happens. I'd love to say it's a panacea afterwards and all that, and all of this just magically happens, and that it happens exactly the way we want it to. Sorry, but it just doesn't. And when it comes to money, things happen. So you want to tie it up as best you can, And we really want to believe that everybody's going to do what we really want them to do. We want to believe that. It isn't always a reality, I'm sad to say. That's the ugly truth of it, so sorry. Okay. Any other questions? Am I hitting things that are important to you, or are we going in an okay direction? Yes, sir.
At the beginning, you mentioned 150,000.
Yes.
Some kind of a cutoff. What is that exactly?
Yeah, that is the 150,000 is before, in the state of California anyway, the market value that of your personal property that will force you into probate if you don't have a living trust, not a will, a living trust. However, that's personal property. If I have 50,000 market value on all of my real property, I'm in probate.
That's pretty much everybody goes back.
Hello, thank you. Thank you. Yes. So now a lot of people will say, well, I've got all these beneficiaries, I've got, my spouse is on it, on a piece of property, and I say, that's exactly correct. For the first to die, what happens when the second dies? We're in probate if we don't have this. Maybe I have a spouse that was married previous with children. And those children, we want to make sure, but now we've remarried, we want to make sure that those children are taken care of. I have to have a living trust, because if I don't have the living trust, by California law pretty much, all of my assets now are going to my new spouse. That new spouse may or may not take care of those children with whatever you wanted. Again, it's making the decisions. What do I want, and making sure, for the most part, that what I want happens. Okay, I don't even know on our little sheet where I am, so. But this is good. This is great. I hope, if I'm helping you with questions, I hope. Okay, so identifying your heirs, again, and how much should they get? I spoke to this earlier about making sure that we motivate them in some way, perhaps, to do what we want them to do. Now I'm no longer here. I can't motivate them. I don't just want to give them X amount of dollars just because I'm gone. Maybe I motivate them to hit certain benchmarks before they get these dollars. Okay, the trust funding. We were hitting on this. This is an important part, and I'm, again, sad to say, this happens. You can have people that have gone through this entire trust process. They actually had a piece of property, had a piece of real estate. They were great at the beginning of this. They funded it. And what I mean by funded is we now have this living trust. I have this piece of real estate. I put that on I file with the county that I have a living trust. I put it in the name of my living trust. That tells the world out there that if I'm gone, there is a living trust. Find that document, because it tells you what I want to happen. It's funded, what they call funded. Now my trust, it's titled in the name of my trust. So now people know to go to the trust, because the trust now will tell everybody what I want to happen. So now we fast forward, again, what I'm talking about, the review. So now we fast forward 5 years go by. In the midst of this 5 years, I have refinanced this house. Uh-oh. Guess what? The lenders make me take it out of the trust so that they can do the loan, and they put it back in my personal name. It's now out of the trust. So when I talk about this review and kind of going through things, you need to keep things in your head. Now, most attorneys will tell you, but a lot of times you'll forget. So again, reviewing these things are the important part. So what happens is now 5 years later, I'm gone. It never got put back into the name of the trust after the refi. Uh-oh. Uh-oh. Big uh-oh. Okay, so again, doing these reviews, so you can be perfect, we can be doing everything correctly, and we have a life change. Again, why I'm talking about these reviews. We keep going back to making sure is everything still titled correctly, or I opened up a new stock brokerage account. I changed my stockbroker. I went from E-Trade over to Charles Schwab. I forgot to tell Charles Schwab, oh, this needs to be in the name of my trust. So again, that review will kind of go back through and say, these are the assets. Do I have them titled? Do I have them not titled? But that's assuming you've all done your living trust. Okay. But that's what the funding is talking about, is the trust funding. Yes, sir.
When you're changing a particular account from one broker to another, okay, when you do the transfer, the title on the account has to be exactly the same. So for instance, if you have an account in a trust and then you change your broker and you transfer the assets over to a different broker, it's going to be the same trust because you have to open it up in the same trust for it to transfer over. So it's not going to be opened up and then taken out of the trust.
If you have a good brokerage house, yes.
Well, no brokerage house would accept it.
Yeah, they will.
Well, I haven't found anyone that would do that.
I've seen it.
Have you really?
Yeah, I have. Unfortunately, I have, yes. So, yeah. So just be careful, that's all.
Usually they have to match the title exactly for you to do a transfer.
Yeah, but what happens when they're doing that paperwork is a lot of them are not on it, as far as a lot of them don't even like the trust name on it to begin with. They still want to go back to, and they'll revert in the paperwork back to your personal name and not even list the trust. Really? So, yeah, it's joyful. So contingency planning. Contingency planning is similar to everything that we've been talking about here, which is just making sure that, in short, that we have our health care directives, we're planning for the well-being of our family, we're planning ahead of time, we don't have these already emotional situations, and that, you know, and the City of Hope is a great example. Again, you have some medical things. They may be with the chemo, they may be on drugs, they may be on heaven knows what. They just want to be done with this. This is not what they want to be working on right now. So, which I'm sure that's what you experienced. I mean, again, I've been there, I've done this. And it's very difficult, you know, then at that point to get somebody to try to make a rational decision. That's why we're here. We're trying to do it ahead of time. It's very difficult, very, very difficult. So I feel your pain with it, but they were so blessed to have you. No, and I'm telling you, and I'm very, very, that's a very heartfelt comment. In any medical situation, if you have somebody that cares enough to be your advocate, you're so blessed. Okay, so the financial world, so back to my contingency plan, so based on like even trading accounts, we have these advisors, they're talking about shorting this, longing that, doing this, adjusting that. They're doing all of this, and when it comes down to this kind of thing, we're not doing that. And we should be. We should be making these contingency decisions now. And yet we'll let all these other things have all of this planning being done for us. And yet something as important as this, we kind of let fall through the cracks. So contingency planning. So the estate planning, what it basically, this contingency plan is is what's going to happen if I do get ill and have a long-term illness, or if I'm gone. So that's my contingency plan. I'm doing that now for my family. So again, I talked about this earlier, the planning as a motivator to encourage these different rewards. And again, maybe I want to do the charitable work or have my heirs do certain things. So again, it can be definitely in my trust as a major motivator if that's what I want to do. Or I just have younger children, I have minor children. Do I want this to go into a different kind of a trust where it doesn't go to one person? Or I mean, there's so many situations, and that's why good advisors are going to walk you through the different situations that you have, because you're going to know that I'm leaving this to my daughter that has no idea how to take care of money. That's a problem. I mean, that's a problem. I've worked my entire life, and I'm going to give this over to you that has no idea of money yet. It's coming, I'm sure. They're going to get it. They're going to get it, but right now they don't. Well, I'm gone. So again, I want to make sure, there's different provisions in there. I have spendthrift positions. There's different provisions that you can make within these to protect the legacy and to protect this young person as well. And they don't even have to be underage. They could be 22 or 23 and still just not get it yet. So that happens. So the consequences of failing to plan, this is what we were talking about with the consequences of not planning, and that's where my probate guy comes in and we start talking about my 10%. That's part of it. The other thing is, if I don't plan, I'm on the state plan. And I don't mean a state plan, I mean the state's plan. If I haven't planned, it's up to them how my stuff is going to get put out there. It's based on law at that point. And that's if you don't have a will. If I have a will, I'm still going, remember, if I have a will, I'm still going into probate probably. Okay, the will not keep you out of probate. Everybody get it? Okay. Okay. Because I think a lot of people, wow, I have a will. Yeah. Okay. The will not keep you out of probate. It tells the state what to do, but they're going to take money away to do that. Okay? So what's it all about anyway? We are the legacy we leave behind. So what is that legacy that we want to leave behind? Do we want to leave behind a lot of paperwork and a lot of mess and stress and probate issues? Do we want to leave behind decisions to be made with people that don't know how to make those decisions, don't want to make those decisions? Or do I want it to be the way that I want it to be, where I have all the choices? I've left an organized, easier situation for my family. I mean, let's face it, death is a difficult situation for us to go through. We're grieving. The last thing that we want to be dealing with is this stuff. We don't want to have to be worrying about the money stuff. We want it to be organized. We want everything to be nice, smooth transition as it can be. And even with the trust, I'm not suggesting that that's the end of all problems financially. It won't be. But we've done what we can. We've tried to be ahead of it. Yes, sir?
And the way I understand this, thank you. The way I understand this and the way I've explained it, I'm a financial advisor and have clients, and I try to explain to them, for instance, if you don't have this trust and you die or something, you and your wife are gone, you have beneficiaries. When that estate goes into probate, it's there for at least, 6 months to a year? Is that what it is?
That's at least.
At least 6 months to a year. So while that's going on, and your taxes for your house have to be paid,
Exactly.
whatever bills have to be paid, the insurance has to be paid. Yeah. They can't touch your assets to pay for it. They have to take it out of their own pockets.
That's correct.
And pay for it until the time that the probate is over.
And that's exactly what we were saying.
So,
this is so difficult. We already have a difficult situation, and I just lost a loved one. And now I'm intensifying that with now, the family home. And I recently had this. The family home. The kids grew up in this home. They wanted this home. Mom didn't take care of it, of the situation. So now we're in probate because she was the second to die. Like I said, we have this idea, well, it's okay, this one's going to get it. Well, okay, but now the second my spouse is gone, now it's me. I'm the only one on this. So now the kids are, they're grieving already. They lost their mom. Now on top of that, they're scared they don't have enough money to keep this mortgage going. But yet it's the family home that they don't want to give up. It's this kind of stuff, and they don't have the money to keep taking care of it. So these are the things. You're exactly correct, though. That's exactly the problem. Yeah, so it's not even just the probate of, okay, we just lost 10%. We now may lose even way more than that because now we can't protect the asset. So do you not think that the wolves are at their door? The wolves are at their door. Yes, ma'am.
When you die, who needs to be notified?
Well, the executor of your estate obviously is going to be notified. Usually that person is close enough in your inner circle that they're going to just know.
Right.
Yeah, so at that point, then all of the death certificates will be handled. All of that will be with your executor. The death certificates will go out to the different accounts. And again, then the living trust gets looked at, what do they want to happen, and then all of that starts happening. There's lots of people.
Death, then we contact our attorney, the one holding the trust?
No, actually, well, you may have to if you know that there's a trust and nobody, again, has discussed all of this with the family. That's why, again, I talk about communication's everything, gang, But if that was the case, that my family knew who my executor was, then generally that executor is then going to pick up the ball and start rolling. Yes. And if they want help, yes, there's definitely a checklist through ours anyway that they could call the attorney, and the attorney's going to give them a checklist. You need to do this, 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 and this. Or you talk to, a lot of times, the tax financial advisor is also going to help through that deal. At least I do at my office. That's
Okay.
certainly.
Thank you.
Any other questions? Was this helpful? Was it kind of what you guys were expecting, or? I hope. Okay. Okay.
What's your name?
Raven is my name. Raven Biso. I didn't bring any cards. I'm sorry. I just put my the name of the company and my phone numbers. And if you want more information, please just give me those. I won't bother you. Trust me. I'll only contact you if you want me to, and then once we kind of speak, we can go from there. But I'm not, like I said at the outset of this, I'm very pleased because I know that just statistically, I know that at least one family will be affected by this today. So that makes me very happy.
Are these offices local?
I'm in San Dimas. One of my offices in San Dimas. I have 3 offices. I have one here in San Dimas. I have one in Huntington Harbor, and I have one in Burbank. My business is actually tax and financial planning, and this is another piece of, again, I'm an overall financial kind of place where we want a one-stop shop where we can take care of all of the financial situation. So we work with AmeriState as our attorney advisors for our clients. Yes, ma'am.
So that your phone number is right here?
That 888.
Yes.
Yes.
It's also on the slide there.
That 516-1151. It should be the same number. Yeah, my name is Raven Biso, B-E-E-S-O. Do you know where Gilead and ADP and all that, right off of Covina Boulevard there? I'm in the back there. Yeah, I don't count, luckily I'm I'm lucky I don't have to have street traffic because I'm way in the back at the end of this cul-de-sac. No, it's great back there. I love it. No, my business is not that street traffic. Most of my business, quite frankly, is referral. So, but we've been in business for over 30 years, so we're very well established.
Do you have a business card?
I don't. All I did was put it on the back of these brochures because I'm not trying to, you know, I actually wasn't trying to sell anything. I'm just trying to educate. That was really, you know, but I certainly will help whomever.